He's already called the police. Apparently they don't prioritize his call. He's in his home. He's in his own home. Is he supposed to get his wife and kids up at 3 o'clock in the morning and carry them outside where all these crazy people are out there? I suggest to you, listen to His Honor's instructions about the law of self-defense. The law is the responsibility of the judge, not me. And I'm not going to tell you what the law is. That's Judge Whitehead's responsibility. But I suggest to you that on the evidence in this case, Mr. Cotnoir's actions were not wanton or reckless. It is not enough for the Commonwealth to prove that he was negligent or careless when he discharged the firearm. If you conclude that he was negligent or careless or made a mistake, that's not enough. The judge will tell you that the state has to prove beyond a reasonable doubt that he was reckless. I ask you to credit Mr. Cotnoir's testimony that he fired a warning shot away from the crowd. I ask you to find that his actions did not amount to reckless conduct. I also suggest to you that the state has not proven beyond a reasonable doubt that Mr. Cotnoir did not act in self-defense or in defense of others, specifically his wife and children. That's right. The burden of proof is on them, the Commonwealth, to prove that he did not act in self-defense. When the judge instructs you on self-defense and defense of other persons, and when you deliberate this issue, please remember the following evidence. Mr. Cotnoir had already been attacked before he discharged the firearm. Mr. Cotnoir had already been injured to the extent that he had to be brought to a hospital and stitched before he shot that firearm. The house was being pelted and the crowd was getting more mob-like. Mr. Cotnoir waited a considerable time for the crowd to leave and the noise to go down. At 2:35, 2:40, he calls the police. He waits. The police don't come. He starts to call the police again when he is struck. He is in his own home. He displays the weapon out the window. Unbelievably, the crowd doesn't leave. They continue their barrage on him and his home and his family. I suggest to you that in these circumstances, he did everything reasonable to avoid physical combat before resorting to the use of force. Lastly, I suggest to you that Mr. Cotnoir used no more force than was reasonably necessary in the circumstances. He discharged one shot. He aimed away from the crowd. Everything else had failed. I fear I've gone on too long. Let me close as follows. Mr. Cotnoir is presumed to be innocent. The burden of proof on all the elements of this case is on the Commonwealth. The evidence in this case, not sympathy. We're not looking for your sympathy. We're not looking for you to sympathize with his wife and kids, and certainly we don't want you to sympathize with the victims either. This is not a case about sympathy. Decide this case on the evidence. Put sympathy aside. It's the evidence in this case that compels the conclusions that the Commonwealth has failed to prove beyond a reasonable doubt that Mr. Cotnoir did not act in self-defense or in defense of his wife and children, and number two, that the Commonwealth has failed to prove beyond a reasonable doubt that he was reckless. I respectfully suggest that the evidence compels you to find Mr. Cotnoir not guilty on all three indictments, and I respectfully ask you to return verdicts of not guilty on all three indictments. Thank you very much.